everyone. Thank y'all so much for being here. We know that this event is kind of a little late, but I think it's also really right on time because we are getting a really good sense now about how all of the ills and the fears that we had were actually now playing out after the inauguration. So as you know, as of, I wrote this down, as of January 20th, the Trump administration has issued 73 executive orders, 23 proclamations, and 12 memos, focusing on areas as broad as foreign relations, as well as things that are domestic, targeting organizations such as businesses, as well as higher education, and of course, private citizens. And this is what we are calling kind of Trump 2.0. The escalation of many of the attacks against race consciousness, against anti-racism, that he began in his first term, which ended in 2020, have now just come rearing back, actually seeming much more coordinated this time than it was the last time. So what we want to do, of course, many of these proclamations, the EOs, et cetera, are of extreme dubious legality. And we have many lawyers out there, including many of our own faculty who are out there in the trenches fighting these EOs and these proclamations as being clearly and quite outstandingly illegal in many ways. But part of the problems that we've seen, and I know one thing I want to talk about, and I think the other panelists as well, have been the ways that these have actually been received on the ground, even with their dubious legality. And so what we're going to do today is talk about a couple of issues that are of particular prominence for issues of racial justice. And so we'll have Professor Cheryl Harris, and she's going to talk about the anti-DEI, getting rid of DEI, excising it out of the federal government. And we'll have Professor Ahilan Arulanantham, who will talk about immigration and issues of what's going on at the borders. And then I'll say something about K through 12 education as well as higher education. But we are going to start with Professor Harris, who is going to talk to us. She's going to present a couple of slides here. We'll move out of the way and we'll go there. Oh, as far as format goes, we want this to be a conversation and we have lots of time. We don't expect ourselves to be up here talking for very long. And so I'll be moderating after everyone has done somewhat of their presentation, and then we'll turn it into a conversation and discussion for all of us to engage together. All right.
Thank you, LaToya, and thanks to everybody for coming. I hope that we do have an opportunity for conversation because, as she mentioned, while we knew this was coming, it still is a shock to the system. It's kind of like if you have to take a cold shower, you know, your mind knows what it's going to feel like, but when it hits your body, it's another story. And I feel like that's been like, it's been hitting my body, what's been happening recently. And so actually having an opportunity to process this with you all is, I think, very helpful. So I have a couple of slides because, I'm chronically like that. But those of you who are in my class know I'm so sorry. But anyway, I wanted to basically tee up this question about the anti-DEI project in the context of the federal government as a way of tying it into what I see as being the overall project here, and one which I think we need to name in order to be able to fight it. So the first one is to basically just look at the two executive orders that pertain to this. One is this one that was, both of these were issued, I think, on the same day, basically ending radical and wasteful government DEI programs and preferencing. Of course, the language is designed to actually make the ideological point right from the beginning. To claim EDI is illegal, right? To claim EDI as a form of discrimination and a form of racial preferencing, and directing basically everybody to every federal agency to excise it from their terminate any and all DEI and environmental justice offices and positions, and to provide the director of OMB with a list of any such programs in the agency. There's a second executive order that is the companion to this one, that in addition to attempting to excise it out of the federal government itself, to basically make sure that any federal grantee or any federal contractor also excises it from their program. So now let's think about who is a federal contractor. Who has grants from the federal government? right? That's virtually every university in the country, which will tie into what Professor Baldwin Clark has to talk about. But the scope of this is quite stunning. So essentially the same move with respect to anybody that does business with the federal government. And with respect to that one, the chilling part, again, I didn't want to just belabor the language, but the chilling part about that one is it also says that it requires grantees and recipients of government funds to certify that they do not engage in any illegal DEI, and it threatens them with basically private enforcement mechanisms. So this was, the second part of this is to also ensure that you actually weaponize a degree of conservative sort of legal activism to go after any contractor that fails to certify or certifies falsely. So fortunately, we have at this point an injunction that was issued, I believe, yesterday or in the last couple of days, issued by a district court of Maryland. I put the link up there. But basically, the court said this is really a problem for a number of reasons. That is, the effect of the EO and the certification requirement is a form of viewpoint discrimination, because it's basically threatening to eliminate the promotion of DEI without a similar restriction on anti-DEI, right, is in effect a form of viewpoint discrimination. Moreover, the court said this language is incredibly vague. What is equity related? What is a DEI initiative? And during the hearing, the court noted that the government lawyers refused to clarify what this means. So the possibility of arbitrary enforcement, the vagueness, the fact that it's a non-neutral mandate has so far held this off. But I think, as Professor Baldwin Clark mentioned, the real objective here is less a question of getting this actually through all the legal hurdles. I think Trump, we shouldn't underestimate it, nor should we underestimate the sort of hostility of the federal court system generally to any form of anti-racist policy or discrimination, anti-discrimination or anti-racist policy. We've seen SFFA as sort of the Supreme Court's embodiment of hostility to these. However, my point is simply to say is the objective here is not purely a legal one. The objective here is one to induce paralysis and fear. And part of that project is also building essentially this iteration, Trump 2.0, is building on the roots of this attack, the fertile ground that has already been laid that frames anti-racism as a disruption of the colorblind neutral order. So once any form of anti-racism is framed in this way, it becomes not only legally suspect, but it also allows for a certain kind of discourse in the general public to affirm that position. And to sort of see how this has played out, I want to take a look at something far afield from court, but I think sort of reflects how the dialogue, if you will, between the popular understanding of racism and anti-racism and the way in which the court frames and understands racism and anti-racism is kind of a two-way street that allows to legitimate a popular frame of anti-racism through the lens of white racial resentment. Right? So here is a billboard that I saw some years ago. It probably was about 2015. I was traveling through Alabama. I was coming from Atlanta to visit a relative of mine in Huntsville. And myself and my partner were driving in the car when she was driving, and then I saw this billboard, and it went by. And I thought I was having, racial PTSD. I was like, okay, you didn't just see that, did you? Right? And as I was starting to sort of sputter and reflect on this sign, I saw this one. And needless to say, it was very unsettling. I'll fast forward because we don't have a lot of time, but essentially later at some point, I went to try to figure out who had put these up, what were they? And you can see on this one here, the little hashtag white genocide. That's an organization called the White Genocide Project. It's listed as a hate organization by several of the groups that monitor these things. And it was very interesting because when I found out, I later found an NPR radio broadcast that talked about one of these, this first one here. It had been put up in a little town called Harrison, Arkansas, that had a history as a sundown town. I don't know if you all know what sundown town is, but it's basically one in which black people understood that they were not to be within the jurisdiction any time after sundown. But this predominantly white town that had been known for its racist practices nonetheless had a chamber of commerce and some kind of community board that reacted very negatively to this sign and said, you know, this is not how we want to be represented. And so they put up a countersign. And the story was basically about how this one little community was pushing back against this framing of anti-racism or diversity, meaning chasing the last white person down, and rejecting the way in which they saw the White Genocide Project as putting them in a bad light. Right? So the question that I posed, and the one that I started to think about, is how did these signs, oh, and by the way, sorry, just to mention, I found out where they came from. This framing actually came from a particular organization, a racist organization, that was headed by a man named Bob Whitaker, who had previously, a long time ago, worked for the federal government, came out of that and started doing what he perceived as a kind of appropriate activism. And this was the mantra that he developed. This became picked up by a lot of white supremacist organizations. You can see it's basically a kind of argument. It's the great replacement theory, sort of run through a kind of contemporary language. And he saw that it was important to actually, and his followers, not a big group, but that they saw really that it was key to actually reframe anti-racism as a form of racism. This was their project to push this out there. And thus, you have these billboards. So the point I'm trying to get at is the question that came to my mind is how did this move from the fringe to the center? How did this move from being an idea that was recognized, cognizable as a white supremacist idea, and then it actually now gets moved into policy, right? It's now actually moved into the mainstream. It's arguably a platform of the Republican Party, right? So how does this happen? And I guess, because we've got a lot to cover, there's a lot to be said about how this happens. This doesn't happen all at once, nor does it all happen, just in this particular moment. But I think what it speaks to is that the moment that we're in is one of crisis, not just a constitutional crisis, but certainly that as well. One in which we are facing what might be called, and what has been called by some theorists, a moment, this is Gramsci, the crisis consists precisely in the fact that the old is dying and the new cannot be born. And in this interregnum, he says, a great variety of morbid symptoms appear. These are morbid symptoms. And it's a symptom of a system that can no longer deliver, right? Not just for people of color, but for anyone, in terms of its commitment to an accelerated form of extraction, accelerated form of kind of taking from the bottom and redistributing from the top, which is essentially what this new budget deal is about, and using and investing in the forms of white racial resentment in order to sell it. Right? The twin ways in which race and sort of this capitalist form of extraction have really accelerated in this moment have produced the kind of public discourse that allows for a sign like that to be seen as normal, right? And to be accepted as legitimate, even as there is plenty of room and I think plenty of people pushing back. My point is to say we do, I think, face some very serious challenges at the moment, but they should not, in fact, I think, delude us into thinking that it's just about this one particular attack. This is a prong of a much bigger attack, and that, in fact, is both daunting but also an opportunity. It's also an opportunity to think about how these struggles are connected, how, in fact, for example, the weaponization of the fight against immigrants is a central part of this project. I mean, this is exactly what this is, right? So this is an opportunity for us to think about where we can make bridges in terms of addressing this crisis. I want to actually, like I say, leave some room for comments and opportunities to think about how and in what ways we respond. But I did just want to put on the table that one of the important parts of this is to recognize that the project of the executive orders is to actually push institutions to anticipatory compliance, to obey in advance, right? And part of what I'm here to say is don't do it. Don't obey in advance. And so with that, I think I'm going to turn it over to my colleague. I'm going to take this off the screen because nobody wants to keep reading it.
Actually, super appropriate. You could keep
Okay,
it up.
just leave it up there.
Yeah, might as well.
Right.
Well, thanks very much for the invitation to join this panel, and it's actually been really helpful for me because I and other people working with me, Hiroshi and others working with me at the Center for Immigration Law and Policy, are very much in the weeds of analyzing and in several cases now challenging different aspects of the Trump immigration policies that have already come into force. And we actually filed a lawsuit last week challenging the termination of temporary protected status for people from Venezuela, which I'll talk about in a little bit. And I think other ones coming soon. And it's actually useful to step back a bit, because from my perspective, one of the things that I at least did not do as much as I probably should have in the first Trump administration is to try to kind of analyze and theorize conceptually a little bit what is happening, much in the way that Cheryl was just talking about, that Professor Harris was just talking about. So I'm happy to be able to do that here for just a little bit. I want to try to take a few minutes here to understand some of the attacks on immigrant communities that are happening now through the lens of two principles of critical race theory. And one of them is an idea that I think is very familiar to people who are steeped in critical race theory, but not always the way people outside of that approach think about law, which is that legal concepts are themselves always being shaped by social and political forces, including structural racism. And so they can change, because those forces obviously are operating constantly and they change. So what counts as discrimination, as Professor Harris was saying, or property, or violence, those things can change. And they change in real time, sometimes for the better, sometimes for the worse, as these forces move and transform concepts. Another one, which is also I think a very sort of important tenet of CRT, as I've at least come to understand it, is that the world is not naturally progressing towards greater racial justice. In fact, I remember LaToya telling me specifically, like, hey, that many people in CRT view this as part of the foundation. It's a little bit odd. It's a common liberal tenet, that idea. It's also embodied in the great statement of Reverend Dr. Martin Luther King, right? That the arc of the moral universe is long, but it bends towards justice. I think that's an important article of faith, and it produces hope, and it allows people to struggle for a better world. But also, I think it's important to realize that sometimes things get worse. That it doesn't naturally happen that way unless you think of the arc being really, really, really long. And you can think of mass incarceration, for example, or lots of times where we might instead say history is repeating itself, or even if not repeating itself, it's rhyming. And here in this moment, I actually think both of those tenets of CRT are clearly on display in what is happening right now in immigration policy. And I think I could pick a lot of different examples that would illustrate these well, but I want to focus on one, which is the legal conception of invasion. What is an invasion? And how is an invasion being used to justify a whole load of the new Trump immigration policy? Because that concept is shape-shifting. It is changing right now in front of our very eyes, and is being used then to great legal effect. And it's actually been used by the government now to undertake massive changes in policy, actually in contravention of statutes passed by Congress. And the reason that the government is invoking to disregard those statutes is the fact that we're under an invasion. So there's two different executive orders that state as their purpose to protect the country from invasion. There's one that purports to guard the states from an invasion, and another one to protect the American people from invasions. These are two of the, however many it was, 73 or whatever executive orders you mentioned. Two of the immigration ones are about that. Now, they've done a whole host of things as a result. One thing they have done is that they have entirely ended, for the moment anyway, entirely ended access to asylum in the border region. And the executive order invokes the fact that we are in an invasion. I'll quote, "The aliens engaged in the invasion across the southern border are restricted from invoking Section 208, the provision of the law that allows you to apply for asylum." Now, that law, Section 208 is a portion of the Immigration Code. It makes asylum available to all people, actually regardless of whether they're trying to cross in the desert or they present themselves at a port of inspection. It is also embodied in a treaty, the Refugee Convention, and the Congress ratified that treaty and implemented it in the Refugee Act of 1980. These are like long-standing basic protections, and they are now, for the moment anyway, suspended or abrogated, and there is, in fact, no asylum access available at the southern border right now. And when the executive order authorized it, it invoked explicitly Article 4, Section 4 of the Constitution, which requires the federal government to protect states from invasion. And most scholars have thought, therefore, authorizes probably all kinds of authorities that would not exist otherwise. Another huge policy shift which the administration has taken, invoking invasion, and this is in the order about protecting the people from invasion, is that they have announced their intention to end temporary protected status protections for some unspecified group of people, but we already know at least two groups that are falling under that, which is people from Venezuela and people from Haiti. Now, to step back a second, the temporary protected status statute is a statute that was passed in 1990 by Congress that protects people who are already here from deportation and also from detention, and it also provides them work authorization. So it's a very important set of protections for people from countries that are unsafe to accept the return of their nationals back. And they can be unsafe because of war, they can be unsafe because of natural disasters, or for a host of other reasons that are specified in the statute. And Congress, it's a very well-written, clear statute that authorizes all of this. And if the Secretary of Homeland Security designates a country for TPS, then all of its nationals in this country who do not have two misdemeanors or a felony or more criminal history can apply and then become eligible and have these protections. And the Biden administration used that statute quite generously, maybe not as generously as it should have, but still quite generously. And by the end of the Biden administration, there were more than 1.6 million people who were protected under the temporary protected status statute. And that's also a product of the fact that there's a huge amount of instability and refugee movement happening, obviously over the last many years, including I think a lot of the dislocation produced by COVID and other things. That included 600,000 Venezuelans who would come to the U.S., including some people who lived here a long period of time, but a lot who came after 2021. A bunch who came after 2013, and then a whole bunch who came after 2021, and then also about 500,000 Haitians. And again, that includes some number who have been here for a long period of time, but a lot who came in the years, more recently, as Haiti has also experienced, huge amount of violence, political instability, ecological problems, all kinds of instability. So the Trump administration, in this executive order, calls the recipients of TPS invaders, and says the Biden administration has facilitated the illegal invasion of, and then a whole bunch of people, including people who have TPS, and then just a couple weeks ago purported to rescind, take back TPS extensions that the Biden administration had put in place for Venezuela. It did them without regard to the statutory timeline and decision-making process. Actually, DHS Secretary Noem did this just a couple days after I think 2 days after she was sworn in as the DHS Secretary. And they're having huge effects in the really short term. If that order goes into effect, 350,000 people will lose their employment authorization and their right to live in the United States, the protection from deportation, in the first week of April. And these are people who, under the pre-existing rule, were supposed to have status at least through October 2026. And now it's going to be gone in 60 days. That's the one we have already sued over. And then just actually the day we filed the suit on Thursday, they announced they're doing something similar for Haiti. They're purporting to take back an extension enacted by the Biden administration, and the expiration time period for that essentially is August for 500,000 people from Haiti. So those are bad enough, but I should say lurking in the background here with this concept of invasion are things that, at least to a lot of people, might seem even worse, even scarier, although I think for a lot of people would say deporting them to Venezuela or to Haiti is about as scary as you could imagine. But if you actually take the concept of invasion literally, the Constitution authorizes all kinds of draconian exercises of power by the federal government in the name of protecting against invasion, which, if you think about it, if there actually is invasion, which I'll get to in a minute, it kind of makes some sense. I mean, for one thing, the government can suspend habeas corpus. People know what that means? That means if the government locks somebody up, normally you can then go to a court to challenge whether your imprisonment is illegal. That core right is habeas corpus. So to suspend habeas corpus is to give the government the power to lock people up without a court having any opportunity to review whether or not that was lawful. And the Constitution has a protection for habeas corpus which says the writ may not be suspended except when in cases of rebellion or invasion the public safety may require it. There's a statute from the 1790s called the Alien Enemy Act, which authorizes the government to summarily jail and deport people if the U.S. is at war with their country. So we're talking about people living in the United States, but who are nationals of another country. The U.S. can jail and deport summarily those people if the U.S. is at war with their country, or if their country is engaged in a predatory incursion, which is a lot like invasion. And again, this kind of makes sense. Like you could argue about whether it makes sense, but certainly there's some historical logic to the idea that when the U.S. is at war with a country and the nationals of that country owe allegiance to that other country and they're actually at war, that at least some restrictive measures arguably could be taken at least against some of those people. That statute's also been misused plenty of times. I'm not sort of defending it, but if you think about it, it's one thing to say it applies where there's actual war going on. It's something very different to say that we're living in the middle of that thing right now, and so it can be used against anybody who counts as an invader, which could be some unspecified, extremely broad set of people. So this sort of gets then to the way in which I say I really believe these concepts are being shaped and morphing before our very eyes. Right? It's a really classic example to me of racism shaping a legal concept. Like, everybody knows what an invasion is in law. An invasion is roughly an organized armed attack, and generally by another country. If not by another country, then some kind of quasi-state-like actor. And there's a load of law about this, and the law goes back all the way to the time of the founding and before that, because obviously people talk about this. James Madison, who owned enslaved people, and it's not necessarily the person you'd want to always cite as like important authority, but he did write a report in 1800 about the meaning. He wrote about a bunch of things, but included in that was the meaning of the term invasion, and it means the same thing in our common conception. That's also how it has always been understood to mean. It's some kind of organized armed attack. But now we can see in real time these kind of racist ideas coming into the mouth of the president and other people in the government, and they are bending the concept by repeatedly calling refugees invaders, calling people who are coming here to work, or because they're scared of returning to their home country, or because they want to join their family, or whatever all the reasons are. None of the reasons are the kinds of reasons that are actually associated with invasion. And yet, by saying it again and again and permeating it throughout the culture, the term itself is shifting, and now it is becoming a legal concept. And this sort of ties into the other tentative CRT that I wanted to just mention briefly, which is about history not necessarily progressing and sometimes repeating itself, or at least rhyming. To justify this use of the term, Trump and also the DHS Secretary, Kristi Noem, and lots of other people in the Trump administration are using not only that term, calling immigrants invaders and refugees invaders, but they're also using a number of the false narratives, and even sometimes the same language, it's the exact same language that has been used historically in prior periods of racist repression against immigrant communities. And it is striking. We did a declaration, actually, for our preliminary injunction motion in the Venezuela TPS case, because one of the arguments that we're making in that case is that this action is unlawful and constitutional in violation of the Constitution's equal protection prohibition, or the equal protection clauses applied to the federal government. We're making that argument, so we've cataloged the statements, racist statements made against Venezuelans. I hate to say, I'm sure we're going to owe significant mental health time off for the people who had to gather all this stuff and put it together, because it's grim, reading all, can you imagine spending 4 hours of your life hunting the internet to find all the racist statements about Venezuelans that President Trump and others in this campaign have made. It's not happy work. But compiling those and then comparing them against the same kinds of language that have been used in different periods of the past. And they were just all there. Poisoning the blood, which is something that Trump has said over and over again in the context of immigration generally and Venezuelans in particular. This repeated trope used in the 1920s because eugenicists, who were trying to push the immigration policy of that time, believed in this idea that the blood could be poisoned by people of inferior races, and it was used to justify the massive restrictions on immigration from people from non-white, non-European countries. This idea of eating pets, this false claim that the Haitian migrants in particular are eating pets, was used against Southern Europeans in the 1920s and 1930s, also against Vietnamese and other people from Southeast Asia in the 1970s. The same lies about that were spread all over. This idea that people are being released from prisons and mental institutions, that other countries are emptying their institutions and that's who's coming here. Something that Trump says constantly, the DHS Secretary says constantly. They say it specifically about Venezuela. It's totally false. People have debunked this. There's not a shred of evidence it's true. This was used in the 1980s in the context of Cuba and other places as well. And then the criminality trope, the idea that immigrants commit more crimes or whatever, is constant. It's all the way throughout history, from the beginning until now. So that's all to say, that's not necessarily happy news, but it is really interesting and important to understand that what's happening now is, I would say, it's not only invoking those things in the past, it's the same thing. It really does feel like it's the same history, perhaps rhyming or perhaps actually literally repeating itself. And I think it's important then for us to see what we're doing in the response in that context. I think what we're doing is resisting that in the same way that people have resisted all the things that I mentioned, that were the subject of massive resistance from immigrant rights communities, from other communities of color, and that's really the important work that I think we have to do today. So I'll stop there.
I don't know if I'm as organized as my colleagues, because I've been thinking about this a lot. So I'm going to talk a little bit about education, and I'm going to focus on K through 12, although I think that what's going on in higher ed is very much a part of it. I don't think we've really listened a lot about what's happening at the K through 12 level in ways that I think are even more concerning. So as many of you know, how is education set up in our country? It's set up mostly at the local level. And we have states that oversee what's going on at the local level, and then we have the federal government that has its own Department of Education. Most public schools only get about 8% of their funding. 8% of total education funding comes from the federal government. It's not a lot of money, but it is billions and billions of dollars, right? Even though it's only 8%. The federal government, though, does other things in public education that are very important. So, for example, they provide all the laws and the requirements for children who have disabilities who are getting services in schools. They give extra funding for low-income schools and school districts. And they also do the vast majority of civil rights enforcement when it comes to racial discrimination in public schools. One of the things that Trump decided they were going to do, and if you read kind of Project 2025, was a whole chapter about how they were going to dismantle the Department of Education, right? Now, dismantling the Department of Education is probably a very, very tall order. It is likely not able to actually dismantle the entire agency. But what they can do is a lot of reshuffling, reorganizing, and directing their funding priorities in a different way, right? There were a couple of things, though, that I think go with some of these EOs that I find to be most troublesome. I want to talk about two. So one is a recent EO that came out on, it wasn't an EO, I'm sorry, it was a Dear Colleague letter that was sent to K-12 schools, universities, that were about getting rid of DEI or diversity anywhere within the public school system and programming. What we found is that there are some, they couch this in terms of SSFA, saying that, well, the Supreme Court said that you cannot consider race in anything, which of course that's not what the Supreme Court said, but that's what their letter said, and said that you can't take race into account even when it comes to things like programming. Why is that important? What we found is that there are some school districts who are voluntarily, with this anticipatory compliance, getting rid of things like black student unions in public high schools, getting rid of these affinity groups for groups of students that they've created for themselves that are not exclusive of other groups, that don't tell children that they cannot join a group because of their race, but they're disbanding these groups altogether, anticipating that this is something that they're going to need to do to comply with orders that are coming down the pipe. I find that to be really, really concerning. On the one hand, I think that, like Professor Harris said, complying in advance is not what we should be doing right now, right? But we have some of these local school organizations that are incredibly vulnerable, that don't have the same type of legal teams out there that, let's say, a university like the University of California can, who are not only being targeted from above, but remember that many of the anti-CRT movement was coming from below. So what we have now is we have the same people who were pushing against things like CRT in schools in 2020, 21, 22 are now being emboldened by what's coming on from up top. And then they are coming into their school districts or going to their states and making many of these same arguments by saying, oh, and now look, it's even better now and more important because the president has said so as well, right? Those are the types of things that are very, very concerning to me at the local K-12 area, local K-12 context, that they just are not as protected as you might think as our universities and our colleges. One thing I wanted to talk about in particular, that's something that's been bothering me, but this idea of how we use terms and concepts and we redefine them in order to make them be used in racially regressive ways. One of the ways I think that this is happening in education is this idea of local control and sending things back to the states. So you know that under the Constitution, anything that's not given to Congress directly is reserved to the states, and education is one of those things, right? So education is the province of the state. It is the state that is required to give education to children if they choose to give education to children at all. And then what the state does is it delegates its authority for providing public schools, delegates that to these local education agencies. The idea of local control was built up at the end of desegregation efforts in the 1970s. The case called Milliken v. Bradley, in which they said there was a case where the state was actually trying to desegregate Detroit schools in Michigan. And the state said that we have the right to do this because we're the state. We had bad policies that segregated children according to race. Now we need to go across school district boundaries in order to fix our mistake, the mistake that the state of Michigan made. And the court in Milliken v. Bradley said, no, you're not allowed to do that because that goes against something called local control. The white school districts that did not want to integrate with the children that were in Detroit did not have to, because we have this constitutional principle of local control that says those who are most close to whatever the activity is, they should be the ones that are actually able to control what it is. And in that case, it was very much these white suburban communities should be able to control who could become part of their school district, who they had to let in and who they didn't. What is happening now is a throwback to this idea of local control, right? That let's give everything back to the states, and not only give it back to the states, give it back to these local educational agencies to decide how children are going to be educated in any particular school district. It is this rhetoric of give it back to the states, give it back to parents who have the right to decide what their children learn, where their children learn. Give it back to them and allow them to make these decisions is part of what is being driven by, I think, the Trump administration to completely break down what public education is supposed to be in the first place, which is this idea of creating a democracy, of making sure that all children have the same resources and opportunities across the country, in a way that when you send things back to the states or you give things all back to local control, everyone can then put in their own, I would say, biases and discriminations within their school systems across the states in ways that will no longer have any oversight by the federal government, right? This is a really, really bad thing, I think, in that states, there is vast inequality of education across states, more than there is even within states. So what does that mean? If you allow every single state to do exactly what they want without any oversight by the federal government, we already have limited oversight now, and educational outcomes across the country are incredibly uneven based on the state in which a child attends school, right? Once you get rid of that, then you have I get really upset about this, but there's no backstop. There's no backstop for civil rights abuses at all. And especially when the particular Dear Colleague letter that came out on Valentine's Day was particularly said that it was, they were fighting against the racial discrimination against many white, and then they throw Asian students in there, and I think they just do that because this is being recorded, that's okay. But against many white students, and saying that that's where the real discrimination is. And, who is that actually targeting then? It's saying that racial discrimination is no longer racial discrimination. Anything that you try to do that has any negative effect on a group that you think is being targeted, then those are the things that are no longer able to happen at schools, right? So is it the case that having a black student union is discriminatory against white students? Is it the case that having any of these types of affinity groups, let's say even among parents, is that something now that the school districts are no longer going to allow to actually happen? I apologize that I'm not being, I don't think, as cognizant or as coherent. But there's so many of these things that are happening at the K-12 level that are just they are so troublesome to me. And a lot of it is because I don't think that at the K-12 level there is enough protection on an individual school district basis for them to withstand or to say we're not going to comply, because what happens if they do have to comply and they lose funding for this or they lose funding for that? The last thing I'll say, how do I know that this is happening? I was just looking it up. So the federal government runs schools, Department of Defense schools. And as many of these public defense schools, so for example, there's a school in Germany that's run by the Department of Defense that now has disbanded all of their affinity groups and saying because the federal government says that we can't have this. There's no way I see that we can look at this and think that this is not going to start happening also in school districts in the United States. And the problem is that, too, the states are really, 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 really bad when it comes to civil rights. They're horrible at it. That's one of the reasons why the federal courts were such a bulwark in protecting people for their civil rights. Every time I hear send things back to the states, I get very, very, very concerned about civil rights enforcement when we put everything back into the state's hand without having any federal oversight whatsoever. While the administration says that they want to dismantle the Department of Education, I don't think that that's actually what they want to do at all. I think that if you really wanted to get out of the business of education, you wouldn't be telling people that their children can have affinity groups in schools. You wouldn't be saying that children with disabilities, one thing that he wants to do is move the IDEA, the Individuals with Disabilities Education Act, move that entire program into Health and Human Services rather than keeping it in education, which is where it belongs, right? And so there's just all of these different things that are working across in the education space. And not to mention, Professor Harris and many other colleagues wrote a wonderful Dear Colleague letter that got released last week, right? That was, again, about this anticipatory compliance, even at the university level, of saying that anything that has to do with race is per se illegal, which is completely just not true. And her letter does an amazing job of doing that. I'm hoping, one of the things that I've been thinking hard about is even in my own school districts and the ones that I'm aware of, is to start writing some of those letters myself to say, look, you do not have to do this. This is what the law says. This is what the law means. That is of dubious legal quality. But to me, it worries me on the small level in that it's like it's going to be whack-a-mole, one school district at a time, one state at a time. And you can't trust even a state like California to be a state that's going to protect. So, for example, there is a law that was recently put forward by Republicans in California that are trying to stop the state from enacting its ethnic studies high school class requirement, right? And saying that the content of these ethnic studies courses need to be better vetted and scrutinized, right? Because they're afraid that there are anti-American lessons that are being taught. There are some foreign policy questions that they don't like the way that they're being taught in the ethnic studies. But this is happening in California. And it has a very strong basis of support. But that's not coming from the Trump administration. That's coming from Californians here. And so as all these different school districts are trying to fight these different mandates and these different pressures that are coming from all of these different areas, they are just incredibly vulnerable and don't have anyone who's actually fighting for them to provide the type of education that we've decided as a country, this is the type of education our children need to have, or decided as a state, etc. All right, I'll get off my soapbox. Yeah. So I think what we want to do now is open it up, have questions, have a conversation. What are the things that y'all are thinking about? Of course, there's things that we haven't talked about that are incredibly important. And there's other faculty in the room who also may have ideas or things that they want to kind of bring up to the group. So I'll field the questions, but let's just have a conversation. Yeah.
This is for Professor Arulanantham. I was wondering, so I'm in political asylum right now, so just the INA is all my business. On the international stage, how is this going to look on America when we're taking hundreds of thousands of people who are potentially refugees or asylees or asylum seekers? If we have a duty of non-refoulement, what are going to be the international repercussions for America as we round up hundreds of thousands of people and deport them?
Yeah, so that duty that she's talking about is the core treaty obligation
the U.S. has an obligation not to send someone back to a country where they could be persecuted under the Refugee Convention. And it was very clear, there's no exception written in this order for that. Some of the early litigation about this actually already has been challenged, is sort of asking the government, or asking courts to say they have to at least do the very minimal screen that's required by that treaty, and also the Convention Against Torture, which requires that people not be sent to places where they could be tortured. And they didn't do that, and perhaps that'll be one of the ways in which people can kind of cut back at this. But I think the broader question, it's really bad, on the world stage, because of course all of the international legal regime for refugee protection is ultimately mostly enforceable by states choosing to comply, and it's all sort of a shared kind of framework that's operating across countries. And when the U.S., which has long touted the Refugee Convention and often honored it more in the words than the deed, but still has honored the Refugee Convention, at least for people who are coming to the U.S. shores. For the U.S. to just walk away from that is certainly going to have a huge impacts all over. And one of the things Professor Motomura, I know, is studying is Europe, because Europe is also going through similar kinds of retrenchment when it comes to refugee protection. I'm sure that the retrenchment here will have effects there and have effects in other parts of the world as well.
And this isn't directly germane, but it actually connects to some ideas that I think maybe a thread running through here. What is the power of law against lawlessness? So basically we have a regime that is lawless. They are running roughshod, as Ahilan just mentioned, over every single precedent. Even in the context of SFFA, as Professor Baldwin Clark said, they're exceeding the boundaries of the law. So what is the role of law when you're facing a kind of lawless regime? I think it is important to use and think about the legal tools, but to understand that this is really absolutely lawless. They come into court and they lie. They come into court and they change their story. How many different ways have they represented who Musk is? He's an employee. He's not an employee. He's the head of Doge. He's not the head of Doge. They have no boundaries. And so it really falls back to the question of understanding the relationship between organizing and law. And oftentimes I think there's a way in which, and I know I've thought this myself, that law is irrelevant, that it's all about organizing, or sometimes you encounter people who think the reverse. These things cannot be thought of as sort of separate domains, because the question that you raise, which is essentially the U.S. behaving in a lawless manner in the context of international regimes, what are going to be the ways in which the law, in fact, is very good at pointing out the contradictions. The question is, what next, right? What it seems to me is maybe another thread that's running through this, and I was thinking about this when you were talking, is the importance of knowing your rights. Knowing your rights is not sort of self-executing, right? The fact that you know them doesn't mean that they will be observed, right? But it does mean that you are equipped to some degree in a way that you are not. And so just as immigrant communities are taking that up, I think schools need to take that up. I think institutions need to take that up. I thank you so much for giving me the credit for the letter, but all I did was sort of do a little twist and sign on. I'll have to say that some of our other colleagues did the laboring more of that, for which I'm very grateful. But the point I guess I'm making is the point of the letter was to know your rights, right? And I think that to me is kind of a thread that runs through whether we're talking about the international arena, state, local government, federal government. That's kind of where I think we are. That's way off of your question, but
It's still good.
Hi, thank you guys for coming. I'm fascinated that, during colonial times it was called conflict, but now it's called engagement. When you're doing it now, or when you have policies, applications, and all this other formal legal process, and now it's an invasion. When you were invading, it was called conquest. So under the theory of conquest, I wanted to know, does it extend to the point that we could see ourselves under martial law and internationally for immigrants? Is it only the border, only the Mexican border that they are suspending Section 208, or is it everywhere?
So the latter question, no, it is not only the Mexican border. There's certainly fewer asylum applicants that come from the northern border, but there are some. In fact, there was a bunch of South Asians to whom they applied the 212F, or this order that we're talking about. For me, the martial law, I'm curious, I don't think I have any particular expertise about this. I think my take about martial law is it is very difficult to implement politically, and even though the administration talked a lot about how they were going to use the army to do immigration enforcement, and some of the papers suggested they would do it within the United States, we haven't seen it yet. We've already seen Guantanamo and seen like all these, and we haven't seen it yet. But it's only been a month, right? So give them time. But I do think the politics of that are more complicated, and so even something like suspending habeas corpus. If that is used a ton against, white people is one thing I would say, but also even non-white communities or people who are very long resident and people who have social capital in the country, I think there'll be a huge amount of resistance to that. But I don't know. That's just me talking. I don't know.
Yeah, I don't know that they actually need to invoke it formally to do some of the things that they are doing, because of the problem that I was identifying at the beginning of anticipatory compliance. So far be it for me to say it's past them. Nothing is past them. But what I'm saying is, to some degree, so if they shifted from talking about using the military to the latest proposal is we're just going to deputize a bunch of private people and let them do it. Yeah. So you don't need the army, right? And in fact, one might argue you don't even need to get the numbers up very high. If you actually look at the number of people that were deported under the prior regime, under Obama, right? The numbers actually exceed what Trump did, if I'm not mistaken.
Yes, absolutely.
So I'm saying you don't actually need formal declaration of martial law. What you need is for people to be paralyzed.
My question relates to dual citizens. I know in the talk we discussed how...
So far, can you speak up?
I'm sorry. My question relates to dual citizens. In the talk you mentioned how people who are under the jurisdiction of other countries are coming to America and they're being turned away for those reasons and it's being classified as an invasion. What would apply to people who are citizens of the United States and also have a citizenship in another country, especially a country who might not be friendly with America?
So the law, if we're talking law, the long existing law is that even if you're a dual citizen, if you are a citizen of the United States, you have an absolute unconditional right to enter the country. And the government can take away virtually everything else if they have enough process. They can even kill you, right, under the death penalty. But this is, and there's cases that say this is absolute and unconditional. They cannot take it away unless you renounce it. You have to take an active step to renounce it. So that's the law, It is also true that the government is now saying that lots of people who were born in the United States, me as it turns out, are not U.S. citizens, because of either their parents were here on non-immigrant visas or were, are undocumented. And so this too, it could be shifting. And there's a debate about this. I think the overwhelming legal scholarship is that view is crazy. And even the attempts to publicly defend it are vastly different legal theories, neither of which make any sense, or even more than two. But that lots of things are up for grabs, and it's a question about how much our institutions will hold, like Professor Harris is saying, and how much law will actually kind of function like it's supposed to. But the straightforward answer to the question, if I were asking advice, foreign students are really grappling whether they should leave the country or not, because there's all these different exclusion rules that apply. My advice to somebody who is a U.S. citizen would be to travel. And I'd say that partly out of anticipatory, not wanting to engage in anticipatory obedience, and also because that part they have not challenged.
That actually would interfere with some other parts of their project too, to some degree. I mean, keeping it as a option actually works as a kind of chilling effect. To actually do it is something else.
How much is protest in the streets still a mechanism that works?
We'll see, won't we? No, I'm serious, we'll see.
I mean, in a way, it means that kind of, what do you mean, what works? What does
Yeah.
working mean, right? And I think that it has always been the case that protest in the street, I think, is valuable and useful. And part of it, too, is because of the issue of, we're not just fighting in the law, we're fighting in the rhetoric, we're fighting in the getting people to understand. Like, there are all these other ways that we need to be pushing. And part of it is to push other people in their own minds and to gather community and to have mutual aid and to do all these things that still need to be done on a very local level.
Mhm.
I think that getting out in the streets and protesting is exactly what we still need to be doing, even more considering that how do you protect yourself, or how do you fight against the lawless, right? It won't be through law. It has to be through some other way.
I think to the extent that, history is any lesson, Brown got passed in 1954. It did not get enforced. It did not get enforced until there was organized, sustained protest. And if we understand that as the relationship that I was trying to allude to between law and social understanding, the law, in fact, for a bunch of reasons that we can go into, changed, but the actual capacity of the system to change did not happen until people pushed it to change. And so it's never the case that I think these things can happen alone. One of the things that does happen, and I think Professor Baldwin Clark was just alluding to it, is it's true that to some extent protests can be an exercise in seeming like preaching to the already converted. But that's not always the case, because part of what has to happen is the sense that we are not alone, and the only way that that happens is if we can see each other, right? And so we'll see, though. We are going to see, for sure.
I mean, there was, someone had written on Twitter or Threads or something where Donald Trump had written something called, like, Long Live the King. And someone wrote, remember the last time that happened in this country when someone declared themselves to be the king?
I would say, I also agree that protest is absolutely essential. Another thing I would say is, I actually think litigation is also essential. I think they're both essential, and it's very hard to know what one would be like, their interactive effects. But I definitely think that judges are humans, and because law is shifting, when a litigant comes to court and says, like, this isn't an invasion, what are you talking about? That's crazy. Like, the ability of the judicial decision maker to have the strength to apply the law as everybody sort of understands it is in part a product of the political and social environment that they're reading about. So I think having street protests and protests in the airport made it easier for all of these judges to strike down the early versions of the Muslim ban. And the demobilization of that, which ironically was a product of the fact that the orders have been put in place, made it easier for the Supreme Court to then reverse eventually, right? Like, so I definitely think that they're both really important.
That actually reminds me of the first time I met you. Trump 1.0.
Oh, the talk I gave there, yeah.
The talk that he gave was right the Monday following the Muslim ban, and he came to give a talk that was absolutely packed because students had already gone to the airport to try to give aid. So here we are again.
Yeah, Jerry.
This is a question that kind of struggles with politics versus law or litigation, and the choice between stopping horrible things along the way or requiring us to hit rock bottom. So here's a political story that can be told. Elections have consequences. We fucked around, we were finding out, and it's the only way to change certain people's views. not everyone's, but that's basically what happened. And politically, people need to hit rock bottom before they can actually change their minds, because of all the ways in which we're disinformed, all the ways in which we're petty, self-interested, care only about ourselves and our politics. And that's just the brute reality of kind of most human beings who are just watching out for themselves. That's the political story, in which case then you actually need people to hit rock bottom. You can't co-enable them. You can't always bail people out. You need people to hit rock bottom. That's the political story. Legally, it's much more anxiety-producing because as you go down that slippery slope, you're creating incremental precedents that create disastrous consequences. Also, obviously, in cases like immigration, for example, when people are, forcibly, either detained, not allowed to see counsel, or rejected, that lesson is being taught under very painful circumstances. That seems disproportionate often in humanity. But I wanted to hear your views, as honest as you're willing to be, about the political analysis that wonders whether the country actually has to hit rock bottom, and whether small preventions of that actually allow the madness to continue in ways that actually over the long term does not serve this nation, and then whether the same analysis applies to law.
So my kind of reaction to that is that I worry about allowing the country to hit rock bottom, because I think the people on whom that is going to fall are going to be people who do not deserve to take on that heavy burden. It's going. I also think. I feel like I don't know what it would mean for the. I don't know what it would look like for the country to hit rock bottom. But my instinct is to say no. I don't want that to happen. I don't think that hitting rock bottom. I think rock bottom looks different for different groups of people. I don't think we would be able to actually agree upon what that bottom looks like or how we know that we've gotten there. And I think that the damage of in a way, kind of putting our hands back and saying, hey, let what happens because of the political consequences. I don't know. That doesn't sit well for me, kind of as a citizen and a participant, to say, this is just what we deserve. Let's see what happens. Now, once we learn our lesson, it's like with your kid, right? You learned your lesson now, you'll never do that again. I'm not sure that we would learn the lesson because I'm not sure that we would realize that we were at the bottom. I don't know.
There's a book by, what's his name? Jonathan. He's a psychiatrist and a sociologist. The title of the book is Dying from Whiteness. And it's a study, a comparative study of what happens in states, conservative states that rejected the extension of Medicaid under Obamacare, and as well as different positions on gun control. And he's from one of these regions, areas, originally more conservative, maybe southeastern Ohio, someplace like that. And it's both quantitative and qualitative analysis in which he goes in and is trying to understand why essentially people voted for something that ultimately hurt them. What was it that allowed them to, not see the consequences of their political choices? And hence the title of the book. One would think that if it in fact is imperiling your own life and the life of people that you care about, that you would be resistant. But what he actually found is that the belief system sort of overrides the facts. The frame actually allows people to reinterpret the facts in ways that, as you would say, or as the question presumes, actually has a very different picture of what the bottom looks like. So today on NPR, I heard there's a program in rural that is attempting to connect people in rural Iowa, which apparently has very high cancer rates, with experts that are remote, but they're using telehealth to basically bring in these specialists to give the people the care that they want. These are the people that voted for Trump and actually have supported this effort to defund federal health initiatives that fund this exact program. They interviewed a woman who is in care, and the best she could say is, well, I still think there's a lot of waste, but I think they should be using a scalpel, not a hatchet, right? I guess you could call that movement. You know what I'm saying? But the point I'm making is even someone whose life is actually dependent upon a different viewpoint is slow to recognize that she's at the bottom. I mean, it's to your point, right? So I think that there is a political psychology around this question that oftentimes is not going to necessarily be amenable to what looks like objective facts. And so for that reason, I think I would associate myself with what you said. I'm not willing to wait until people perceive that they're at the bottom. And I'll think of the author's name after we leave. Okay.
Yeah, it's such an interesting question. I just want to say a couple of things briefly about it. First of all, I agree with both of you. Or I'm on that same side. I mean, obviously, we're like litigating and doing all this stuff, so we must sort of be there at some level. One other consideration I would add is it's not just the bottom is, and maybe no one knows where the bottom is, but also that if you think about the ability of the government to protect its own power, and there, you put in the levers of control that then make it harder and harder for resistance to work. This is like the story of authoritarianism, right? But it's also the story of the Supreme Court from Bush v. Gore to now. You make it harder and harder to undo the power that the court has, and as the doctrine entrenches itself, and then they can expand their power on the shadow docket and all these. Like, there's lots of ways in which this happens. So I would worry about the bottom being a spot where you can't get out of it, or it's really hard to get out of it because of these things that they're only able to do, once you're kind of dropping down the tube. That being said, Jerry, I talked last week with several Venezuelan TPS holders and people from that community who were, from Republican community. I mean, I imagine probably, I would guess that the families of the people we're representing, I would imagine more of them are Republican than Democrat families, and a number of them were genuinely shocked that the administration had done this. There's just all this political support in Florida. I mean, Marco Rubio lobbied for the extension of TPS, and now he's the Secretary of State. And it is a little bit harder. I think there's something when you say that it's a little bit harder to stay up super late to represent people like that. We'll still do it, absolutely we'll do it. But it is a little bit tricky when you're like, you brought that. You're the people who kind of did this. So yeah, it's a complicated problem.
Thank you to our panelists, and thank you to all of you for joining us today. And take extra lunch.